session.
Good morning. Please be seated. This is the time set for argument in the matter of Letona versus Arizona Department of Corrections et al. Our civil number 18-0590. Each side will have 20 minutes within which to present their arguments here today. Appellant may reserve some portion of that for rebuttal, but it's up to you to keep track of your time in that regard. We have read the briefs. We've been through the record. We've conferenced the case. So we've got a pretty good idea of what happened below, although I can't say that it's a perfect understanding. And so perhaps we'll be discussing some of that here this morning. We're recording the proceedings both by audio and video. And so when you approach the podium, please identify yourself and your client for us. With that, appellant may proceed.
Good morning. I'm Donna McDaniel. I'm here with Martin Bin, and we represent the appellant Carlos Letona. Now, Your Honor, what I want to do is to try to clear up any kind of misunderstanding or confusion that you guys have about the history of this case. Respondents both started their briefs by saying Letona got what he asked for, and I'm here to tell you that he absolutely did not get what he asked for. He still hasn't. What Letona did is he got fired in December 2015. He appealed to the Personnel Board. The Personnel Board said, we don't have jurisdiction. Superior Court said, yes, you do. So when it went back to the Personnel Board for the appeal to be heard, by that time, Carlos, Mr. Letona, had already been out of work for a year. So we contacted Arizona Department of Corrections, ADC, and said, hey, put him back to work. Pay him his back pay. You have to follow the procedures. You didn't give this man any due process. You cannot uphold any discipline without due process. Their response to us was an absolute no. We're not doing it. So we filed a motion for summary ruling with the Personnel Board. We told the hearing officer the same thing we told Department of Corrections. They simply can't win. You cannot fire someone without giving them any due process and then go to the Personnel Board and try to uphold it. They can't win. So after we filed it, then Department of Corrections reinstated Letona, but said no back pay. They said, we want to go forward with this appeal. We want the board to make determinations under 381106.
Well, the board didn't say no back pay, but it said that issue needs to be decided.
Correct. The Department of Corrections said at this time in December 16, we're not giving him back pay. We're going to wait. We're going to go through an appeal hearing, and we want the board to make that determination. They said we're entitled to have a hearing. So what we weren't told as representatives of Letona, and what Letona was not told, is that when he was reinstated in December of 16, his reinstatement was processed by Department of Corrections as a rehire. Now, in the record, it refers to a break in service. And I want to make very clear what I'm talking about is when I say there's a break in service, what that means is when you look at Letona's personnel file, it shows he was fired in 2015, December 2015. There was a break in service, and he was rehired in December of 2016.
Is that in the record? Does the record show that's what the current status of the file is?
Well, nothing shows the current status of the file, but the most recent status of the file shows the break in service.
And when you say most recent, what would the date of that review be?
That would be the, it's attached to my brief as page 54, and the index of record, it's at 35 Exhibit 30, and Exhibit 1 to Exhibit 30, and what it is stipulated findings of fact between the parties. And those were in May of...
All right, but that pre-existed the board's directive and the Superior Court's finding that the file essentially needs to be scrubbed, and a memo from Department of Corrections saying it has been scrubbed in that regard, right?
No, the memo from Department of Corrections saying it has been scrubbed was in April 2017. Department of Corrections gave me that memo saying this break-in service is removed from the file, and then a month later they stipulated that the break-in service was still in the file.
did they subsequently agree to correct that?
No, and there's no evidence that they ever did. There's nothing in the record to show that it was ever scrubbed from the file. Break-in service, as far as the record goes, the break-in service is still there.
Is that his remaining beef? That the file does not, that the file reflects a procedural history that needs to be reflected differently?
That's part of it. Part of our beef is that his personnel file does need to be corrected so that it does not show a break-in service.
Before you go on to the other one,
Oh, yes.
what should the file say? Should it say termination rescinded, or should it not speak of a termination at all? What is your contention it should say?
It should say the termination was reversed on appeal. Because that's
Reversed
what
on
should have
appeal.
happened. If the law had been followed, if the board had not repeatedly said, we don't have jurisdiction over this, the board would have had no option but to reverse on appeal because Letona was fired without any due process and without any allegations of misconduct.
What's his complaint if it was rescinded? So if the file reflects that the firing was, the dismissal was rescinded?
If the dismissal was rescinded, his complaint is that the Personnel Board lost jurisdiction and we've been fighting before the Personnel Board for 4 years for no reason. Our complaint is that if Department of Corrections did rescind the dismissal, of which there is no evidence, they've never given us anything saying this dismissal was rescinded, if they had rescinded it, the board would have had no jurisdiction. There would have been no point in December 2016 for the Department of Corrections to say, we're going to go forward with this appeal because the board has to make findings under 381106.
It's very confusing, but we are where we are. If the file reflects his termination was rescinded, what moment is that? So what right now?
I'm sorry, I don't understand the
What
question.
is the problem right now because we can't go back and undo history.
Okay.
If it reflects that his termination was rescinded, what is the effect? What's the problem with that right now to him?
The problem right now is that we have gone through this. Letona was entitled under the law to have his termination reversed. It wasn't reversed, wasn't rescinded. Right now, the record before the Personnel Board shows that Letona was dismissed. He also got a suspension of 80 hours, and those are both in his record. And if his termination had been reversed, as it should have been, the only way that he could have gotten an 80-hour suspension is that if the Personnel Board had found that there was some basis in the record for that suspension to be imposed. And they could not do that because there was no due process.
Isn't your complaint about the 80-hour suspension the subject of a separate appellate remedy?
It is, but first we need to determine whether or not this discipline was reversed or rescinded.
Is the concern that the distinction between reversal and rescinded might lead the parties or the court, the board, in the other proceeding to think there was some merit to the dismissal when you contend there wasn't?
Your Honor, my contention is, honestly, my bottom line contention is there's no evidence of reversal or rescission. So if you argue about the distinction between the two, if it was rescinded, then the Personnel Board has no jurisdiction to do anything. If it was
to do anything with respect to the 80-hour suspension, or
the Personnel Board has no jurisdiction over the 80-hour suspension anyway, because the Personnel Board can only hear appeals of matters that are greater than a suspension of over 80 hours dismissal.
But I guess I'm having a difficult time understanding why it matters to your client.
It matters to my client because his personnel record shows he's been disciplined twice for the same thing. It shows that he was dismissed.
But if it shows that that dismissal was rescinded, then the personnel file would only show a suspension. Is that correct?
That's correct.
And does he have an argument there that if the current file shows that the dismissal was rescinded, what's the remedy that you would be seeking?
If the current file shows the rescission, I would want to know when the rescission happened, whether it was before or after he filed a notice of appeal. Because once he filed that notice of appeal to the personnel board,
Why does it matter if the remedy you're seeking is to have your file accurately reflect that punishment was taken away?
it
It's
makes a
not-
difference because once the appeal was filed, the personnel board had jurisdiction. And once the personnel board had jurisdiction, the only option, the only legal outcome under the statutes was that there should have been a finding of no just cause for any discipline. And
Wasn't there such a finding?
no, because the personnel board declared that it had no jurisdiction. And once the personnel board declared we have no jurisdiction, they couldn't make any valid findings.
And
But
you're-
after it was sent back?
That is the third order that the third and final order that the personnel board made is we're declaring that we have no jurisdiction over this matter. That was October 2017. That's the order we're appealing to today.
Okay, I'm sorry to interrupt, but when was the last time Mr. Letona or his lawyers saw his personnel file?
I have not physically seen his personnel files.
So you don't know what's in there.
I only know what's in the record.
So, and what we have are avowals, at least in the briefs and before the court, as to what's in there.
Well, you have avowals in the record, but you also have contradictory avowals weeks later. You have an avowal in the record with Arizona Department of Corrections saying in April, we removed that break in service. And then you have Arizona Department of Corrections saying in May, the break in service is still there.
Well, I'm sure they'll have something to say about that here in a
I'm
few
sure.
minutes.
And if you don't have questions, I'd like to reserve some time.
All right,
Thank
thank
you.
you. All right, appellees.
May it please the court. My name is Kirsten Story, and I represent the Arizona Department of Corrections in this appeal. With me is Jeff Topple, and we'll be splitting our time today between the Department of Corrections and the Personnel Board. I'll be discussing this court's jurisdiction as well as some of the procedural history questions that you brought up earlier. I'm also available to talk about the rescission and the record concerning rescission and Letona's fee request. Mr. Topple will be talking about the Personnel Board's jurisdiction and its authority to act in this case.
Can you start off by addressing this purported inconsistency between the representation that the file has been scrubbed of any reference of termination
Certainly.
and rescission, and counsel's indication that a pleading your office filed or your client stipulated to show that it didn't? So.
I think the opposite is actually the case. And so if you look at the record appendix, there's an exhibit to the parties' joint stipulated findings of fact that contains a memorandum that lays out in chronological order exactly what happened with Mr. Letona's personnel file and also Mr. Letona's data in the Human Resources Information Solution System that DOA maintains.
Where is that in the file?
It's
In the record? What number?
EIOR 35 at page 30.
What
And
was
the
that
name-
attached to?
Yeah, or the name of the document?
The name of the document is the parties, I think it's the joint proposed findings of fact that were submitted in May 2015. I'm sorry, May 2017. And in that, it clearly sets forth, it goes step by step. So for instance, in December 2016, all of the actual documents constituting and reflecting the dismissal and the dismissal were removed. So that includes the notice of dismissal itself, the internal administrative documents that ADC fills out to effect the dismissal. All of those were pulled from Mr. Letona's actual personnel file, which is maintained by the Arizona Department of Corrections. It is correct that it did come out at the February 5th hearing I'm sorry.
Yeah, I'm just listening now.
It is
The-
true
the
that it
good
did
parts.
come out at the February 5th hearing that the Human Resources Information Solution System, the computer system that maintains kind of the data related to someone's personnel information, did reflect a break in service. So it actually reflected an adjusted date of hire that needed to be corrected. So after learning of that, the department turned around, worked with the Department of Administration to get that date corrected. That was corrected by March 29th, 2017. And in any event, the personnel board made darn sure that to the extent there's any discrepancies, those would all be cleaned up in the October 2017 order, when it clearly and explicitly said, the dismissal has been rescinded. We reverse any reference to any dismissal anywhere in the personnel files and the personnel records. If there's any reference, it's to be removed because the dismissal has been rescinded. There's been no finding of just cause. Dismissal is reversed. And so to the extent Letona has any sort of relief that supposedly he wants in this court, it's already been provided by either the department or by the personnel board in this appeal. It's done, it's over. There's really no sort of remedy for this court to provide. And in that respect, now that we've gone through a full briefing period and there's been an oral argument at this point, Letona's had 3 bites at the apple to tell this court how he's aggrieved by what happened in the personnel board and by the personnel board's final order of October 25th. He has not done so. If Mr. Letona is not an aggrieved party, in essence, there is no jurisdiction in this court either under RCAP 1.
Is the computer database, the electronic database that you mentioned, is that
Correct.
the personnel file?
No, it is not.
So there is a hard copy file or some other file?
Yes, so I think the department maintains it as both a hard copy and then there's an electronic backup as well. But the personnel file is maintained by the department itself. Separate from that, there is a Human Resources Information Solution System, which all state employees have access to. They utilize it for time reporting, pay information. I think there's some benefits information.
I think
We do
we've
our
seen that.
open
I
enrollment.
think we've
Yeah.
seen that.
Yeah.
As I've used it, what, are there issues about the electronic database reflecting something different than the actual personnel file? Could there be some confusion in that?
Currently, no, because the adjusted date of hire that came up in the February 5th hearing was corrected after the February 5th hearing, and it had been, and it was completely corrected as of March 29th.
So it shows an original date of hire.
Yes,
And so that's something that he can review online himself.
correct.
But the hard copy, the actual personnel file, is something that is available only at ADC, I take it?
ADC has it, but he has access to his personnel file at any time. He can always request a copy of his personnel file.
Do we know in the record when the last time a then current copy of the file was afforded to Mr. Letona?
That is not in the record. However, the April 2017 order is in the record. And it does set forth, what was put into his personnel file, what was taken out of his personnel file, and the dates on which that occurred. And by March 29th, the record was basically sanitized of reference to the dismissal, including the notice of reinstatement that he received at his request in December 2016. That too had been removed from his file, and that's documented in EIOR 35 at page 30. And if there was anything else left in the record, to the extent it was, the personnel board ordered it to be removed and expunged. Now, from the department standpoint, there was nothing else to do at that point anyway. But, even so, if there was an issue with it, the personnel board took care of it in its final order. So, in essence, Letona got everything he wanted and asked for, even the relief that he's talking to you about now today. It's at minimum in that October 25th, 2017 order, but he'd received it before then as well. So again, he's not an aggrieved party at this point. Under Chambers versus United Farm Workers, this court has no jurisdiction if
He
he's
can
not an aggrieved
request
party.
a copy of his file today, tomorrow. There's no impediment to him
Correct.
seeing what's in the file.
Correct.
So we've been told this morning that the problem, that his problem is twofold, as I understand it. One is that the personnel file shows a break-in in employment, a break
Yes.
gap, and also does not say that the original termination was reversed.
So the
You-
personnel file would not say that the termination was reversed, because we've been ordered and we agreed to remove any reference to the dismissal from the personnel file, right? So if we're going to say the termination was, the December 2015 dismissal was reversed, then that would be a reference to the December 2015
The fact that
dismissal
there
in the
was a
record.
dismissal.
Exactly. But what does exist is the October 2017 order, which clearly says, twice even, that the dismissal has been reversed. So that record does exist. It provides Letona with the relief that he's requesting in the form of a record.
I'm sorry if I'm being so, if I'm having a hard time understanding this, but does the personnel file reflect that there was a that he was reinstated? Which I think is another way of getting at, was there a termination? Does it say?
There was
Okay.
a reinstatement notice that was originally placed in the personnel file that has been removed. It's been
Okay.
removed since, I think, April at the latest.
Okay, and my third question is, does the personnel file reflect that a termination was rescinded?
There is no notice of rescission.
Because there's no notice of the termination.
Exactly. So
Okay.
to include a notice of rescission, again, would necessarily reference that December 2015 dismissal. And our direction is to completely expunge that record of any reference to the dismissal. So it's not there, basically, to help Letona and get in the sanitized record that he so dearly wanted.
So, to your understanding, the only adverse notation in that file reflects the 80-hour suspension?
Correct.
And is
So
that-
in December, he was issued a notice of charges, and he did get a dismissal as a result of the notice of charges, which was decreased to an 80-hour suspension. That's in there. He was disciplined, but that's not appealable.
Okay.
If the court has any further questions, I'm happy to entertain them at this time, but I'd like to give Mr. Topol
You're saying the
balance.
break-in service is something that your co-counsel will address?
I can address the break-in service.
But that's not reflected in any of ADC's records?
No. Because as indicated in the memorandum that is attached to the parties' joint stipulated findings, it reflects the complete sanitization of his record, including HRIS of that information. And in any event, even if there was after that, the personnel board took care of it.
Thank you.
Thank you.
Thank you. Jeffrey Topol for the Arizona State Personnel Board. Thank you for your time. I just want to touch on a few things. I think my co-counsel touched on many, and we've addressed a lot of the underlying issues in the briefing, which I think is really clear. However, one of the themes here is that this is an agency, the Personnel Board, that overreached. And I think it's important to keep in mind that this saga, if you want to call it, because there has been a lot of things that happened since the appellant's original dismissal, started with the Personnel Board saying we don't have jurisdiction. So this certainly is an agency or a board that's looking to reach beyond its authority. There's, of course, a lot of briefing with respect to the issue of whether the board had jurisdiction. I think the appellant takes a very narrow view of the board's jurisdiction, which is not consistent with the legislature's enabling statute, which is ARS 41782. And then they address the board's authority and touches on various other statutes, which, they suggest limit or otherwise circumscribe that relatively broad authority to hear and review appeals relating to the dismissal of covered employees. We think certainly everything that the board did within the context of these proceedings falls within that jurisdiction. With respect to just one thing in particular, I mean, as my co-counsel certainly noted, we do have some questions. This is a unique situation from our perspective in which an individual was dismissed, came to the board. Again, we initially said there wasn't jurisdiction after, and then ultimately, after it went up to Superior Court, we accepted jurisdiction. But everything from our perspective, and you've gotten a little more, shed some light on some of those factual issues that the appellant has asked for in this case. He was dismissed, his appeal was heard, he was ultimately reinstated in March of 2017. He received his back pay. So this presents somewhat of a unique situation as we see it. They got the result they wanted. They're questioning how we got to that result. The other thing that I just want to note is the appellant has repeatedly said that the board declared that they did not have jurisdiction and points to the October 25th order from the board. I don't think it's nearly that clear. Certainly there's no explicit, we don't have jurisdiction. What I think the appellant is relying on, the hearing officer had recommended that we declare no jurisdiction. The board ultimately adopted some of the recommendations of the hearing officer, not all of them, and I certainly, there's no express declaration of no jurisdiction in that October 25th, 2017 order, and I certainly think the board's subsequent conduct demonstrates that it certainly believed it had continuing jurisdiction under the enabling statute, which again allows it to hear and review appeals relating to the dismissal of covered employees, and I think their conducts, subsequently, the board was doing, essentially granting the relief that we believe the appellate was requesting. Of course, there's those factual issues that have been addressed here today in large part, but I think that's really from the board's perspective where we're at. So if you have any questions, I'm happy to take them. If not, I want to give you an opportunity to finish up on some of those other issues as well. Okay, I appreciate your time.
Thank you. I think the last issue we need to discuss here is the request for attorney's fees, and so I did want to clarify a point on that after having reviewed the reply brief. So Letona has only made a request for fees under ARS 12348A2. Under section 12348H6, however, it states that this section, as in all of 12348, including subparagraph A2, does not apply to proceedings involving the Personnel Board under Title 41, Chapter 4, Article 6, unless the state has made the appeal. This appeal to this court is a proceeding involving the Personnel Board under Title 41, Chapter 4, Article 6. The Personnel Board is here. It's a party. These proceedings involve the Personnel Board, and the appeal to this court is enabled by ARS 41783G. That's what enables this appeal, and that section falls under Title 41, Chapter 4, Article 6. So any attorney's fees are precluded by the plain language of Title 12, Section 348. If you have any questions, I'm happy to entertain.
Oh, thank you, counsel.
Thank you.
I want to read to you from the board's brief. What they say is, Hearing Officer Murkow issued his report and recommendation, which included the following findings. 1, no just cause existed for Letona's dismissal. 2, Letona was entitled to full back pay and benefits, less administrative effects, or receipt of income from alternative employment. 3, the board enter an order finding Letona's reinstatement constitutes an equitable rescission of dismissal. And 4, declare that the board has no jurisdiction to consider Letona's dismissal appeal. After the full Personnel Board hearing on this matter, the Personnel Board adopted Hearing Officer Murkow's report and recommendation in total, with the exception of the recommendation that back pay and benefits be determined by another state entity. They adopted the finding or the recommendation that the board had no jurisdiction to hear it. It was very clear when you look at their brief and look at their order. You'd asked me earlier the difference between rescission and reversal. 1, if there was a rescission, if the board does not have jurisdiction, if there's a rescission, the board cannot reduce Letona's back pay. So Letona was aggrieved in the amount of $6,000 because that's what the board ordered he shouldn't get back. The other difference is.
Do you dispute that it was reduced based on monies that were earned at a different job?
I dispute it if there was a rescission, because that provision, 381106K, which allows that reduction, only applies if there was a reversal. It doesn't apply if there was a rescission. The other difference is, as Ms. Story told you guys, she said that his dismissal was reduced to a suspension. If it was rescinded, it cannot be reduced to a suspension. The suspension would be a separate thing.
Didn't they in fact initiate separate proceedings? They sent another notice of discipline. Started a
They
new
sent another
process.
notice of discipline, but then when we made the argument about rescission and reversal, then they started saying, no, we just replaced it. That's in the personnel file, that his dismissal was replaced with a suspension, and they can't do that if it's rescinded.
No, wait a minute. I'm sorry. You've never seen the personnel file.
I have seen the personnel file.
All right, when's the last time you saw it?
The last time I saw it would have been, look this up, let me find it here, that would have been in May of 2017. And that brings me to another thing I want to point out to you.
So you don't know what's in there?
I know
now.
what's in the record as being his personnel file,
My
and that's
question
what's on
is,
appeal.
You don't know what's in there now?
I don't know what's in there now, but I'm going to tell you this. This memo on page 54 of my opening brief, it's the April 6, 2017 memo where the Department of Corrections says, based on recommendations from the Personnel Board, the following items were removed from the personnel file and from HRIS, which is Human Resources Information Solution System. That's where they talk about scrubbing the file. That's where they talk about removing the break in service. This memo is dated April 6th. The stipulations, which are on page 50 of my opening brief, paragraph 34, Letona provided evidence that as of April 20th, 2017, his MAP and his HRS file still contained an entry that he was separated from state service.
There's a subsequent order directing that be.
The
taken
only
care of.
subsequent order directing that that be scrubbed is the same order where the Personnel Board declared that it didn't have any jurisdiction.
You know, I'm kind of wondering, wouldn't it, perhaps we should have ordered the state to bring the file today so we could see it.
Well, Your Honor,
If the file is as counsel has represented,
as someone who likes to get to the bottom line, I would agree with that, but as my understanding of the rules and the court rules and the law and the statutes, we have to look at the record before the Personnel Board.
But the record shows that corrections has been ordered to do something. And
Well,
if,
I'm
if they
sorry.
haven't done that, you would have another remedy. You could ask to see that, and you could initiate a different proceeding. But this proceeding ended with an order that they do something, and they now say they've done that. It's hard to understand why that's part of the record, and there's nothing that suggests that corrections hasn't done what they've been ordered to do.
The thing to me that suggests that corrections is not going to be required to do what it's ordered to do, regardless of how much I want it to happen, is they can always fall back on the fact that the Personnel Board didn't have jurisdiction to make that order. That's why I appealed to the Superior Court. That's why I'm coming here, because you're telling me your remedy is to enforce that order. I can't enforce it because the board in that
Your
order
remedy is
declared that it has
to
no
ask to look
jurisdiction.
at the current file and see if they've complied with that order. And if they haven't, then you can initiate some proceeding, presumably.
And with respect to your argument about you're worried they're going to assert there's no jurisdiction, they've asserted in their briefs and stood up here in open court and said, yes, we had jurisdiction. They're not going to, they can't take a contrary position later
They
on.
have taken a contrary position. Their order says we're declaring that we have no jurisdiction.
well, I don't think that argument is being made on appeal, and it wasn't made this morning.
That argument was absolutely made on appeal. That's in my brief. I discussed the fact that the board declared that it had no jurisdiction.
Counsel, respectfully, it's in your brief. It is not in their briefs. They have not taken a position that the Personnel Board did not have jurisdiction.
Oh, I'm sorry, I misunderstood that. What I'm saying is in their briefs, they're taking a position that's contrary to their own order.
Right. Yeah. And this morning, it was reiterated. I saw you work, or you say, the issue, counsel said a termination was reduced to a suspension. I understood counsel's reference to mean to this, a reference to that the subsequent disciplinary action. In the subsequent disciplinary action was indeed the initial determination to be imposition of a termination, and that was reduced to a suspension?
No, that's not accurate, Your Honor. As you would see in the stipulated facts, I'm going to try to find it.
Okay, I can look there. I don't want to take your time to do
In the
that.
stipulated facts, when Letona grieved that 80-hour suspension, the response to him, and I'm not quoting because I don't have it in front of me, but their response was basically, we've already reduced your termination to a suspension.
Okay,
They didn't replace, they didn't rescind one and have a whole new action. What they did is reduced it. We reduced your dismissal to an 80-hour suspension, and
okay, I understand your point now. Thank you.
somewhere it's IOR 35, Exhibit 30. Those are the stipulated facts that's in there. I just don't know where.
Okay.
Your Honor, just with my last 2 minutes, I just want to address the fact that you're asking me to discriminate between a reversal and a rescission. If there was a rescission, my argument, as you'll see in my brief, is that the board has no jurisdiction. If there was a rescission, the board could not have determined back pay. And if there was a reversal, the 80-hour suspension couldn't have happened. So the reversal is required under 381106. The reversal is required in order for the board to have authority to determine back pay. 381106 also says the board has to make the just cause finding. The just cause finding would say there's no just cause for any discipline to be imposed. Discipline was imposed. If it was reversed, again, if it was rescinded, the board can't make findings under 381106. If it was reversed, the board can make findings under 381106, but the Department of Corrections cannot then impose another disciplinary action. The department cannot unilaterally reduce that dismissal that's on appeal to the board to a suspension. What I'm trying to tell you is all these things cannot happen together. It's one path or it's the other path, and what they've done for some arguments is say, well, when we talk about it this way, it was a reversal. When we talk about it this way, it was a rescission. But the bottom line is you can't have it both ways.
So I'm starting
And they
to
didn't prove either.
I'm starting to understand that your point is that if ADC didn't properly follow procedures the first time around, it is after it can't go back and discipline him another way.
That's correct. That's 41783.
But doesn't 41783D suggest that even if you find that there isn't enough for the punishment that was given, that there's something, that a lesser discipline can be imposed?
Under 41783, a lesser discipline can only be imposed to the extent that the agency, here being the Department of Corrections, has provided sufficient factual basis to impose some form of discipline. And in this case, because there was no due process, the agency could not put forth any basis, factual basis for any discipline. So 41783 would not have allowed the Personnel Board to modify the discipline in this particular case.
Thank you, counsel.
Thank you.
Appreciate the arguments here this morning. If it is matter under advisement, we will issue a written decision in due course. With that, we are adjourned.